Jaguars receiver Zay Jones appears in Duval Court following domestic battery arrest. Let's get into this right now. This is your Nashville lawyer, Andrew Beasley, and this is a Florida domestic battery case. I am licensed in Florida. I'm a member of the Florida Bar. However, I've, for many years, practiced here in downtown Nashville. So I do know a little bit about Florida's process, but let's get into his initial appearance right now.
All right. Good morning. All right, Mr. Cox.
Thank you, Your Honor. Please the court, Hank Cox, on behalf of Mr. Jones, with respect to the particular permit statutes in Rule 3.130 and 3.131, under all the circumstances and background, I request the court release Mr. Jones under recognizance without any special conditions. I say that because he's 28 years old.
Okay, so he's asking the court to release him on his recognizance, basically meaning he shouldn't have to be on pretrial release, he shouldn't have to post a bond, he shouldn't have to have any special conditions. He's good guy, college graduate, he doesn't have a record, he can be trusted to show up for court. And that's what the defense is requesting.
So he grew up in Texas, he moved to North Carolina, he graduated from East Carolina University. He is a resident of Jacksonville. The person who made the allegation lives in a nice home that Mr. Jones provided for in Orlando, and she works in Orlando. So they are 150 miles apart on a regular basis.
So that's a very important thing for his attorney to bring up, that she lives in Orlando, something that is always in the back of the minds of prosecutors or judges is, are these two people going to get into an argument again? And this case, it was just a scratch on the neck, but, is next time, is a deadly weapon going to be involved? Is somebody going to get injured? So very important point for his lawyer to say that she lives over 150 miles away.
The issue of the young child that they have is something that can be resolved in another forum, not here.
Okay, so he talks about the issues of their young child being resolved in another forum. And that is true with domestic violence cases. The criminal is just one aspect. At least here in Tennessee, there's almost always a different judge who is deciding custody, and that's kind of a whole separate matter. Although when they get into no contact with the child's mother, then obviously there's some overlap, which they're going to get into here in just a second.
So with that, I don't see anything under either the rules or the statute that would warrant the necessity of a bond.
Right. You wish to be heard on bond state.
Yes, Your Honor. We would just ask that there's no victim contact placed in this case, and we would defer to the court for a bond amount.
All right. 5 probable cause for the rest of the charge. Set the bond at 2503 with no violent victim contact.
And let me just break down a little bit. That was the prosecutor that was requesting no contact at all, and now the judge is issuing his order, setting the bond at $2,503. There's a very interesting number. There's all kinds of reasons that judges do that. I've seen some judges that do it just so they know and everyone else knows that they set the bond. Some judges will set kind of not nice even round numbers for that reason. I don't know why this judge did it in this case, but like I said, I've seen sometimes where I think it's literally just so that judge knows if they were the one that set the bond. Also, very importantly, he ordered no violent contact, which means that Mr. Jones will still be able to contact with his child's mother, and hopefully they can still arrange visitation. That makes a huge difference in a domestic violence case. Of course, a prosecutor may argue, well, they can always come back. They can always petition to change that bond condition down the road. But, it's always best, I think, if it's appropriate, for him to be able to still have peaceful contact, which clearly the judge thought it was. And I do think a big part of this was that the child's mother lives over 150 miles away in Orlando, that the judge only said it as peaceful contact, meaning he can text her, call her, arrange meeting of the child. It may still be a good idea for them to not have direct contact or exchange their child through a third party, but at least they are allowed by court order to have communication with each other.
There's an alleged victim in the case. Next court date is 12/6, 9 o'clock, 403 for arraignment. I'm sorry, I'm going some words. 12/6, December 6, 9 o'clock, courtroom 403 for arraignment. All right, you have anything else?
No, Your Honor, but just for scheduling purposes, since you had just moved another matter on the 6th in the afternoon, could this be on the afternoon? So
Sure.
Do the vote at the same time?
I'll set it at 12/6 at 2 with your other case. 12/6, 2 o'clock in 403. Okay.
Right. Thank you very much, Your Honor.
Thank you.
Thank you.
Okay.
Excuse me, Your Honor, is that with pretrial services?
No.
No, thank you, sir.
Okay, so he's not going to be on pretrial with a bunch of supervision and conditions. He's going to pay his $2,503 and he's going to get out of jail. One thing, just getting into the allegations a little bit, they have this quote from the report. I observed several small scratches on the victim's neck consistent with marks from a fingernail. And the consistent with is a pretty common, police tactic to say, hey, this evidence was consistent with marks from a fingernail. Okay. Well, is it also consistent with her hitting him and then him having to get her off of him? Yes, it could be. Is it also consistent with them having a big, shouting match and then she scratches her own neck before she calls the police? Yes, it is. Is it also consistent with her, maybe threatening the child and Mr. Jones, having to intervene and maybe, does scratch her neck? So from someone who's seen a lot of police reports over the years, very common for officers to put, what the evidence is consistent with, but of course they don't always put, other things that it's consistent with, which is not, their theory of the case. But it sounds like overall that Mr. Jones has a good lawyer, and he's going to have to work through this process. Obviously, it'll come out in court, but domestic dispute, something that could happen to anyone, something that does happen to anyone. Here in Tennessee, our initial appearance is a little different, done by a magistrate. There are times when I, do go with a client to turn in at the jail, but it is not nearly this formal. And Florida has a much more formal process that requires, the attendance of the defense lawyer and the prosecution at these things. So what we've just witnessed is a much more formal initial appearance than what we have here in Tennessee. But we will see how this plays out. I hope you enjoyed the analysis, and I'll see you again real soon.